The general rule in contract law is that promises have to be performed, at least when conditions precedent to those obligations have occurred. But there are exceptions to that rule. There are times where courts will excuse the duty to perform for a variety of reasons. In other videos, I'll talk about the impossibility and impracticability doctrines, which generally are seller's excuse or seller's remedies. And those occur when the object that is to be sold or the service which is to be provided, it's impossible to provide that good because it's been destroyed, or impossible to provide that service because a person or thing necessary for it has ceased to exist or never came into existence. And usually that's an excuse the seller or the provider of that service will make. We're now going to talk about when the buyer or the one who's obtaining the service can get out of their obligations to pay for it or purchase it because their purpose in purchasing or acquiring that good is frustrated, and they no longer have a need for that good or that service. The origins of this begin with the famous case of Krell v. Henry from the King's Bench in England in 1903. So in this case, we have an event which was the foundation of the contract, which did not occur. And the question is, does the person who is going to attend this event still have to pay for that ability? So this again has to do with the buyer or the receiver who doesn't want to pay for something because it no longer suits their purpose. So the context is that in England they have coronations for kings and queens, and they were going to coronate King Edward VII. And this is a gala event in which it's very popular to attend and to witness. And so some very fancy people were invited to attend this event, and others would have to watch from a window or from the street or from some other procession. And this procession was going to occur along the street called Pall Mall. And this street, Pall Mall, had many apartments on it. And so this contract regards the rental of an apartment on Pall Mall, and not even really a rental, but really a window was the kind of concept, the window of this apartment on Pall Mall, because it had a great view of this grand procession. And the renter who wanted to watch this procession paid an exorbitant amount for what would be a day's use of this room, because really it was about watching this event. And in fact, the room was advertised as being a good viewing room for this event. So the parties really understood that the purpose of this rental was exclusively to watch this coronation. And this would have provided a wonderful view of the coronation event, except for the fact that the coronation didn't occur at that time. The coronation was rescheduled or postponed. So what had happened here was an unexpected event, an event that was certainly not certain to occur. The future king became very ill with appendicitis and needed an operation. So he was absolutely unable to attend his coronation. In fact, at that point wasn't clear he'd survive this procedure. So the event had to be rescheduled, and so the room was to be rent on a specific date, and now that purpose of watching the coronation no longer existed. And in this case, which really established the doctrine of supervening frustration as we know it today in the Restatement of Contracts, Section 265, and in common law elsewhere, held that the tenant did not have to pay for the room because the purpose of owning the room was really exclusively for the viewing of this coronation. It was well established by the parties that was the only purpose of the room. And the renter, the landlord, would be able to re-rent the room at that same exorbitant price in the future. So I feel like the court really allocated the risk of loss to the landlord here because this was certainly not expected. This was almost an act of God. This was a tragic event that was not predictable and was not predicted, was not foreseen by either party. So the question is, which of the party is going to bear the risk of that loss? Which of the party is going to have to pay the bill, right, for this unforeseen event? And that happens in contracts, that happens in life, that there are unforeseen events that the parties didn't negotiate for, and the court assigns that risk in this case to the landlord. And again, the facts for that are the landlord was getting an exorbitant amount for that room, had rented that room for the discrete and established purpose only to watch the coronation and for no other reason, could re-rent it in the future. But the court does say we need to be careful about this doctrine, because if we allow this too often, we erode certainty in contracts being performed. So Krell versus Henry is our first case in which we establish this doctrine of frustration of purpose. And that doctrine of frustration of purpose, or discharge by supervening frustration, in modern law is found in the Restatement section 265, which reads, where after a contract is made, and by the way, that's what makes this supervening frustration. It happens after the contract is made. There are other provisions that have to do with frustration that occurred to no one's knowledge prior to the formation, but we're going to focus on subsequent events that happened after the formation. So after the contract is made, a party's principal purpose, their main purpose, the reason for the contract, is substantially frustrated. So not made totally useless, but what do we mean by substantially? Well, we'll have to tease that out a little bit. How much is enough to cancel the contract? Without his fault. So it's important to assign fault. If a party is at fault for an event not occurring, we're not going to award them an excuse to get out of the contract. And frustrated without his fault by the occurrence of an event. So some type of event that intervenes, that supervenes before the performance occurs. And the non-occurrence of this was a basic assumption, almost like an implied term. So it was almost implied in the contract for the rental of this room on Pall Mall that the coronation would occur. That was effectively like a condition precedent to the renting of the room, because that was the purpose of the contract. So we use this concept of implied terms, and here we refer to it as a basic assumption. So this basic assumption on which the contract was made, in this case that the coronation would occur, did not occur, the non-occurrence of that event. And when that happens, the obligor's remaining duties, in this case the person who would pay for the room, to render performance are discharged, unless, and this is important, unless the language or the circumstances indicate the contrary. So parties are free to assign the risk of loss in their private agreements, and they could have had what's called a force majeure provision. The contract could have said that the room is for rent regardless of whether or not the coronation occurs, and it didn't say that. But parties are free to contract out of the excuse doctrine. So the force majeure doctrine, which we'll talk about a little bit through this lecture, but mostly in other lectures, the force majeure doctrine, that's the idea that parties will actually stipulate in writing what their intentions are if an unforeseen event occurs. These doctrines, the excuse doctrines of impracticability and frustration of purpose, only come into play where the parties have not assigned the risk, have not indicated in their contract who bears the risk of the loss. And a more fulsome way of looking at this is to think about this as commercial frustration. And under the doctrine of commercial frustration, if the occurrence of an event not foreseen by the parties and not caused by or under control of either party destroys or nearly destroys the value of performance. So again, the idea is that it has to almost entirely destroy the purpose of the contract for one of the parties. If it nearly destroys the value of the performance or object or purpose of the contract, the parties are excused. Now that's only true, again, if the event was unforeseen and unforeseeable, if this was really something unexpected, unpredicted, and not discussed. If the event was foreseeable, if the parties reasonably should have provided for its occurrence, then the assumption of a provision in the contract providing for such an occurrence indicates an assumption of the risk by the promisor, meaning if it's foreseeable that the coronation would be canceled and it's known that coronations may happen or may not happen, then the person renting the room bears the risk of that coronation being canceled. They're sort of rolling the dice and hoping that they get a view of a coronation and not of a canceled coronation. So the event has to be really unforeseen and unforeseeable. In determining foreseeability, courts should consider the terms of the contract and the circumstances surrounding the formation of the contract. And we limit, therefore, the use of this doctrine so we preserve the certainty of contracts, and we really only use it in cases where the parties did not and should not have accounted for some type of future event, some event that was unforeseeable and unforeseen. So let's take a look at another case, which is New Beginnings versus Adbar. New Beginnings is a a halfway house or a home for recovering drug addicts and alcoholics, a treatment facility, and Adbar is the landlord who is going to rent to them. So we again have a case of a landlord and a tenant. And so we have a contract for the lease of a building in St. Louis, Missouri, to be precise. This is a more modern case here. This is 2002. And the lease was rather expensive, really. It was $273,000 over a 3-year term because it was for a rather large facility. The facility here is shown on the map, by the way, not a particularly up neighborhood. There has been a bit blighted, but obviously there are residents nearby. And one thing to note about these treatment facilities and other such things is there's a phenomenon called NIMBY, not in my backyard. We all agree that treatment facilities are good for society, but when push comes to shove, many people don't want one locally because, well, for a variety of reasons. And there are a number of contracts that pertain to all sorts of things that are good for society, but people may not want locally. And think about like a nuclear power plant. You know, nuclear power is clean and efficient, but you wouldn't necessarily want to be living, 9 miles from it, right? Or even wouldn't want it next door. Or a paper factory, right? I mean, we all use paper. It's very useful. We're glad there's paper, but it's very stinky to live near a paper factory. So it's not surprising that the tenants here, it got, as we'll see, under some scrutiny by the local government. So the parties disagreed because New Beginnings signed this lease and then had trouble getting an occupancy permit to run this rehab facility in this location because the local government was really resistant because of this NIMBY phenomenon. There's a lot of pressure for them not to authorize this. And in fact, the local officials threatened to pull funding and to cancel the contract. So there were a lot of threats against this company, against this rehab facility, but they did get their occupancy permit in the end. In a very summary fashion, the trial court actually held, this was overturned by the way, but the trial court actually held that in the case of New Beginnings purpose was frustrated because the actions of the local government, the aldermen, prevented the conduct of the business, prevented the business from going forward. And therefore, these actions by the council to stop this rehab facility from opening in St. Louis destroyed the purpose of the lease, because what's the point of the lease if you can't have the facility? And what's the point of the facility if you can't operate the program in that facility? That was the whole point of the lease, was to operate this facility there. And therefore, it excused the defendant's performance under the lease because it was frustrated. But again, the trial court was overturned on this one. And so what this shows is that while you can make these arguments to have frustration of purpose, these facts were really not enough to show there was an actual frustration of purpose. And the appellate court, as I mentioned, is going to reverse the decision from the trial court and gives the following reasoning for why the frustration of purpose doctrine does not apply here, why the purpose was not sufficiently frustrated to allow for excuse. And this is a good reminder because courts really are reluctant to use the excuse doctrines because it would really unravel a lot of contracts and shift the risk to the inappropriate party. So number one, New Beginnings didn't actually have its funding rescinded. It was threatened to be rescinded, right? It didn't actually have its money taken away. There were just these threats. And moreover, honestly, New Beginnings should have been aware that state funding is uncertain. I mean, funding is almost always somewhat uncertain, and state funding for a project which is contentious or is getting disapproval from the neighborhood, this possibility was definitely foreseeable. In fact, it was even probably foreseen because these conversations happened during the course of the lease negotiations. So again, New Beginnings really had that risk of the funding being rescinded. And moreover, the funding wasn't actually rescinded, so it didn't even happen. The truth is that New Beginnings, I think the appellate court is right here, as you can probably tell. New Beginnings should not have been surprised that the local council tried to keep a drug abuse and alcohol treatment facility out of their backyard. This NIMBY phenomenon is well understood by folks that are in this industry, and they need to be aware of it and be working with council. And really, it's their job and not the landlord's job to bear this risk, because they are the ones who can avoid this risk, right? New Beginnings can go to the council and make its arguments and make its plea for the case and negotiate and work things out with the alderman. That's really not the job of the landlord. And moreover, it'd be difficult for the landlord to do. So in this case, New Beginnings is what we call the least cost avoider. It's less costly for New Beginnings to avoid this risk, and more appropriately, a risk they should take. Therefore, they don't get the excuse defense because the risk was not only foreseeable, but it actually didn't cause their purpose to be totally frustrated. So the appellate court holds that since neither the value of the performance nor the object of the lease was destroyed or nearly destroyed, in other words, the building remained intact, it was still inhabitable, and New Beginnings could still move in there and operate a treatment facility, maybe with less funding, maybe with less contracts, but it wasn't totally frustrated, it wasn't destroyed. There was still that value there. There was still some value. Maybe it wasn't $11,000 a month of value, but that's not the test. That would put all the risk on landlords. And how would that affect landlords' behavior? If landlords had that level of risk, they might be much more picky about who they lease to. Anyway, it's more appropriate for the business and not the landlord to take the risk that the business is not going to be profitable or get its contracts renewed or adopted by the state. So in this case, unlike in Krell, this is the two ends of the spectrum of the cases, New Beginnings did not achieve frustration of purpose. So let's review when frustration of purpose occurs. Frustration of purpose is a doctrine that allows the buyer or recipient of a good or service under a contract to not perform its obligations to pay, to not take the value of the contract because the purpose of that contract has been frustrated. And either the value for them is destroyed or nearly completely destroyed. So if you want to put this in numbers, you don't think like 50% or 70%, but 90%, 95%, or 100% destroyed. The value has to be nearly gone or entirely gone for this doctrine to be adopted. And it's narrowly tailored. So the elements of it are that we have to have a party who has a principal purpose. So the first step is to identify the party who's seeking the excuse of frustration. What is their principal purpose in having this contract? What is this contract meant to achieve? And that purpose must be substantially frustrated. And that means that they're getting 0 to 5% of the value that they expected from the contract, that they basically are getting almost no value or no value. And it must not be their fault that happened. So if you set fire to your own building, you don't get to claim excuse because you can't inhabit it. That should be maybe intuitive, but it's part of the elements. So the party must not be at fault and must be substantially frustrated in achieving its principal purpose in the contract. What does cause that frustration is the occurrence of an event, some type of happening, some supervening event that happens subsequent to the signing of the contract, and the non-occurrence of that event must have been a basic assumption on which the contract was made. And this gets us to that foreseeability dimension. So the parties must have assumed that some event would not happen, and they didn't actually think about it or talk about it or predict it. And in fact, this unfortunate event did happen, whether that's the king getting appendicitis. I mean, who would have predicted that? A coronation. I mean, this coronation was being planned for probably a year, and it was suddenly canceled. That was very surprising. Many people were surprised by COVID. COVID was very surprising to many people. Maybe we, in retrospect, should have seen it coming, but there's a basic assumption that in commerce that the world isn't going to shut down, that we're not all going to have to shelter in place because there's some type of pandemic or emergency. So that's the type of event, and the assumption is that that won't occur, and the non-occurrence of that event is fundamental to the contract. When that happens, the frustrated party's remaining duties are discharged. Again, this is usually the party who is supposed to pay, and therefore they do not have to pay. And once again, another limitation, unless the languages indicate to the contrary. The parties can allocate among each other, between themselves, the risk of an event. And when that happens, the courts will not use the frustration of purpose or impracticability defenses. It just will honor the intentions of the parties as the contract says them. and that's called a force majeure clause. And so after this video, I invite you to watch my video on force majeure. And if you'd like to, you can also watch my video on force majeure and COVID contracts, because a force majeure provision is exactly when that last element is not met. A force majeure provision is language in a contract that indicates circumstances to the contrary of a frustration of purpose. And that is the frustration of purpose doctrine.